We're live? Okay. Thank you. Good afternoon. Today is Wednesday, March 3rd, 2021. I'd like to welcome everyone to the continuation of the Racing and Gaming Subcommittee Work Group on House Bill 940, Gaming Regulations of Fantasy Gaming Competitions and Implementation of Sports Wagering. Again, this will be a second work group we've had. We will have another this evening, really tonight, beginning at 6:30 until 8:30. And so let's begin. Let me have a recap. On Monday, we discussed aspects of sports wagering, including license structure, costs, including application, annual and renewal fees, and taxes on proceeds. It was a very informative and discussion on those areas. We touched briefly on minority equity workshop, so let's begin with that. We turn to some of the aspects of this aspect of the bill with comments from the analyst George Butler.
Thank you, Madam Chair. So as you will recall, there were studies conducted during the interim of the sports wagering industry to determine whether or not any disparities within the industry existed. The determinations were found that a disparity existed, and now next steps would be undertaken under the bill by the Sports Wagering Application Review Commission in consultation with the certification agency and within MDOT, the Governor's Office of Small, Minority and Women Business Affairs, and the Office of the Attorney General to review that study and then first determine whether race or gender neutral measures may be implemented in order to address the identified disparity. And if those race and gender neutral measures are insufficient to address the disparity, whether or not race and gender conscious measures are necessary, and if so, to factor those in to its review of applications. In addition, there is also minority participation goals with respect to procurement of services and construction related to the industry. That can be found on page 17 of the bill under section 9-1E07. Those are the primary elements of the bill with respect to minority and business equity measures. There was written testimony and suggested amendments regarding these, and I'd be happy to discuss those next at your pleasure, Madam Chair.
Let's pause and ask if any of the colleagues have any questions about what the analyst has just offered. I know that part of the discussion will talk about ownership and what is allowable and what is not. So first, let me pause and ask if there are any questions of the members. Okay, I don't see any.
And Madam Chair, if I may,
Delegate
Hornberger has a question.
No, it's a problem. I'm not sure how I'm looking at these hands. Thank you very much for pointing that out. Delegate Hornberger.
Thank you, Madam Chair. Just to put that in plain speak and make sure I'm hearing that correctly. So basically, the board did determine that there are racial minority disparities in the industry and that we are to address that as we see fit. Is that a good read?
The State Lottery and Gaming Control Commission, in response to last year's legislation, contacted with a third party to conduct a review of the industry, and that third party did identify a disparity. And now it would be incumbent on the state to take action in response in the regulation of this new industry. The other element that I neglected to mention earlier was one factor that's a part of this is, at least as the bill is constructed, is the competitive licensing for both Class Bs and the mobile licenses as introduced as part of an element of that.
Thank you.
Okay. Thank you for that. I believe there were, Delegate Rose, you have any? No. Okay. You were going to start with offering some amendments that were provided through written testimony or oral testimony.
Yes, there were several amendments regarding minority equity ownership that were presented by Bet on Black LLC in its written testimony for House Bill 940. The first would require applicants for sports wagering licenses to include an affidavit concerning minority and women owners, employees, and any other information considered to be necessary for the review of the applications. This is similar to legislation with respect to the Maryland Medical Cannabis Commission, and I believe that was under Title 13, Section 33. I'd like to say 03.1. Don't have the exact pinpoint site offhand. Let's see.
So George, you're absolutely correct with that provision that was a sticking point when we rewrote the regulations for medical cannabis for that affidavit to be included to ensure that minority ownership was truly minority ownership.
And if I may correct myself, it's Section 133305.3 of Health General. The second component.
George, sorry, Madam Chair, before we move on, I don't know process-wise if we're having amendments brought up, I mean, do you want us to sort of in principle decide whether to adopt them or not? Because it sounded like Delegate Barnes was saying that he thought that we should adopt that affidavit.
Right now, I think what I want to request of the analyst to do is provide relevant amendments, and we're not adopting right at this point.
Okay. So you don't want us making any decisions yet, but just discussing and asking.
That's correct.
Okay, great. Thank you, Madam Chair.
The second amendment that was suggested was to require sports wagering licensees to annually report to the commission. In this case, it would be the State Lottery and Gaming Control Commission, concerning, once again, minority and women owners, employees, and any other information considered necessary. This is also a component of the regulation of the medical cannabis industry. In addition, the stakeholders suggested that to require the Sports Wagering Application Review Commission to actively seek to achieve racial, ethnic, gender, and geographic diversity when awarding sports wagering facility licenses and mobile sports wagering licenses. This is similar to a requirement under the Health Journal article, once again, with respect to the Medical Cannabis Commission. I believe that is included under 133302. The one matter for your consideration would be whether or not geographic diversity is necessarily a component here. That might only be limited to your Class B licenses as opposed to all licenses. But I would leave that to the subcommittee's determination.
Can you explain that, George?
Certainly. So if you will recall, under the Medical Cannabis Commission, the General Assembly did determine that geographic diversity was one of the key factors in awarding licenses. In this instance, you have Class A's where those are going to be fixed locations, depending on the nature of the license holder. You also have with mobile, that's going to have statewide reach. So geographic diversity with respect to those applicants may not necessarily be germane. And then Class B's, those are going to be your competitive licenses, and maybe those are something that you would like to have geographic diversity regarding. You already do have a component in the bill that would provide for some geographic diversity due to the radius around the proposed location for the Class B. So its inclusion may or may not be necessary in this instance for the SWARC to take into consideration, or as I said, if you do wish to include it as parallel to the Medical Cannabis Commission, then I would suggest that you limit to the Class B applicants.
Okay, thank you.
And I'm looking for other questions. George,
Delegate Rose has a question, Madam Chair,
thank you.
and it appears
And
Delegate
Delegate Hornberger. Delegate Rose.
Thank you, Madam Chair. Just to follow up with what George was just explaining, which you did very well, thank you. I guess my only thought on the geographic issue is, again, kind of the same theme that I've been talking about. I just feel like this is something new, and I think we should, allow any jurisdiction or any, small business that would like to participate or apply to participate. I just feel like we shouldn't limit, locations. I think if it works for your business model and you're fortunate enough to be awarded one, I think that if you fit all the other criteria, I just think for a sense of fairness and openness, that would be my preference. That's all. Those are my thoughts.
Thank you very much. That's very helpful. Delegate Hornberger.
Yeah, just to read that back again. So it sounds like there's, and if we're looking at the cannabis as a model, there's some precedent for saying we can't have these licenses clustered around each other, because from a brick and mortar standpoint, that's going to dilute the market share and then represent other areas that may want to have income. Is that a good read?
Sure. I think that those are fair points. I don't believe that there's necessarily a legal requirement to require geographic diversity, but I think that for the purposes that you just described, that geographic diversity is a factor that this committee may wish to emphasize.
Okay, thank you.
All right, but again, George, you offered that there were multiple options for the subcommittee to consider. So again, you've heard I believe you offered 3 or 2, I'm not unsure, but this will, before we make a final decision, all of those factors will be addressed again, correct? Well, I'm citing it will be addressed again. Okay. Any other, Delegate Smith? Thank you. Good morning. Good afternoon.
Thank you. Good afternoon. It's okay. Thank you, Madam Chair. I just wanted to get a bit of clarity, and maybe George can help me, and just also piggybacking on what I thought I was hearing from Delegate Rose, is that ultimately we do have an expressed intent from the proposal to have diversity in many different respects, geographic, racial, what have you, in terms of the people that are participating in the industry. I guess I'm trying to figure out, are we across purposes in maximizing that intent if we identify locations and kind of identify who gets something up front, because we lose the leverage to try to entice that to be a part of the application process. The best kind of, in the application process, if you don't have to do something, if you know you're going to get something without doing something, then like your commitments around issues of equity, just for conversation's sake.
Delegate Smith, you were going in and out, but I think we heard the gist of your questions. George, do you want to respond to that? Thank you very much.
I think that Delegate Smith raises fair points for your consideration. Once again, currently as structured, both Class Bs and the mobile licenses are competitive applications. Only Class As were those where, as introduced, there were any guarantees to the degree that you wish to characterize them as such under the bill. And then just once again, with respect to geographic diversity, I just want to highlight the 10-mile radius that is included on page 15 with respect to Class B locations under 9-1E06 A2 Roman 3.
Okay, are there
And there was one final suggested amendment by Bet on Black LLC. That was to require applicants to undertake efforts to solicit and interview a reasonable number of minority investors and submit a statement that would include the names and addresses of all those interviewed. Currently on page 31, subsection I, which is lines 11 to 20, those actions would only be taken if the applicant is seeking investors in the entity applying for the sports wagering license.
all right, again, that is a recommendation for an amendment for the subcommittee's consideration.
I have a question, Madam Chair.
Absolutely. Thank you, Delegate Lawrence.
And George, maybe you can help me out. So the number of affidavits, that's for Class B licenses is the amendment, correct?
I'm sorry, would you rephrase that?
So anyone applying for a Class B license would need to produce an affidavit of their ownership status.
I believe that the suggestion by the stakeholder was to have all applicants for sports wagering licenses under the subtitle to submit an affidavit of that nature.
So that's Class A, B, or
Class
mobile.
A, B, or mobile, correct.
And that would be of their ownership group, correct?
That is correct.
Okay.
And then to likewise require annual reporting on those matters.
And that would be, that affidavit would have to be prior to an award of an application.
Yes, it would be included with the application itself.
Okay.
All right, any other questions relative to minority participation?
Delegate
It
Holmes.
appears Delegate Hornberger has a question, Madam Chair.
Thank you very much. Delegate
Okay.
Hornberger?
I like the part about the affidavit. I think that's important, or a charter or something along those lines. However, to make sure I heard correctly, you said that a third party would be evaluating these affidavits and then grading them as opposed to the state?
No, sir. When I was referencing a third party earlier, that was the Lottery and Gaming Commission had contracted for the review of the sports wagering industry to determine whether or not a disparity in the industry existed. With respect to these affidavits, those would be reviewed by the Sports Wagering Application Review Commission as part of the application review process. And
Great.
then
That's
in
good.
the future years, submitted to the Lottery and Gaming Commission.
Excellent. Thank you.
Okay, are there any other questions? All right. George, did we cover participation goals in the amendment, or were they cited in the bill itself? I have
Sure.
just my, okay.
I noted earlier that there is a minority participation goal that is included as a requirement. That is, sorry, on page 17 of the bill.
Okay.
This is 9-1E07B as in boy. And they would be subject to MBE participation goals. This would be the state participation goals. It was suggested that instead these goals should be tailored to the individual applicants rather than imposing the state goal on the industry.
I'm sorry, Madam Chair.
Delegate Barnes?
Yeah, I'm not clear on that. Can you explain what you just said?
Certainly. So
Are you reading from page 17 in the bill?
Yeah. Yes.
Okay.
So currently, as drafted, the bill would subject the sports wagering licensees to the state's MBE participation goals and any other corresponding provisions of law. These goals would apply to construction and related procurement. The concern is that these are general goals with respect from the state's perspective. These are general participation goals. Instead, these should be tailored more narrowly in light of the sports wagering industry. And so those would be based more on an applicant basis. And so those determinations would be made in consultation with the Office of the Attorney General, GOSPA, the entity, the SWARC, to have individual participation goals for each applicant. Because depending on the composition of the applicant's ownership, maybe you don't need the same goal for each applicant or for each licensee.
Well, when you talk about the MBE goal, are we talking about ownership, or are we talking about construction or any other? So why
It's
would
construction and procurement of services.
Why would I tie the ownership of my MBE to the work that has to be done?
I think that it all is a question of whether or not any remedial measures are narrowly tailored in each instance so that they can be strongly supported from a legal standpoint.
That's just because I'm the owner of my company. That means I can't hire other African Americans to do the work because I own 51%.
No, it's not saying that, sir. I think it as to whether or not it might be a requirement imposed on you, I believe is one of the matters. Once again, I think that the suggestion would be to narrowly tailor this. So the other situation where this was done on a per project basis was with the wind industry. And the suggestion was to revise the language based on that statute. That's not to say that there aren't going to be participation goals. It's just they're going to be tailored to each of the licensees.
Yeah. And the state MBE goal is what, 29%?
Honestly, I do not know offhand. I can look into that and get back to you, sir.
Yeah, if we can find that out before we make that decision. Thank you.
Happy to.
Yeah, this is Earl Lewis with MDOT. Yes, it is 29%.
That's what I thought. Okay, thank you, Mr. Secretary.
You're welcome.
Delegate Barnes, can you refresh our memories regarding the participation goals as they relate to medical cannabis? Because again, in some ways, this bill or this legislation pretty much can parallel with what we were able to do an advance in medical cannabis, but there were also some areas in which there was not enough participation as we had hoped for. So the participation goals, were they definitive in medical cannabis as far as you remember?
They were, and I don't have it in front of me either, but I
Get
just,
that?
yeah, I don't recall it being tied into what George just explained. So.
All right, Delegate Hornberger.
Yeah, this actually piggybacks, thank you, Madam Chair, on that question that was just stated. And in terms of the sensitivity of this being the speaker's bill, has there been any outlines or guidance giving on what the ultimate goal looks like in terms of percentage of ownership or number of licenses granted to minority-owned companies? Because I feel like we're just kind of trying to speculate on where we want this bill to end up.
Madam Chair.
Alex. Okay. Delegate Lucas. All right, let's go with
I'll defer to Alex.
Alex Hughes. Thank you.
Thank you. Yeah, just to the point of the speaker's intent, we worked extensively with the Attorney General's office dating back to the fall to determine the best way to maximize minority ownership in this new industry that's being stood up. And essentially what we got to was that the SWARC, the Sports Wagering, whatever, George helped me, Advisory Recommendation Commission, would be the body that would work with Secretary Lewis and MDOT to make a determination as to what the appropriate points would be through regulation. So that would be something that would come back through ALR, similar to what happened in the medical cannabis program. So the legislature would have another opportunity to sort of review the process prior to the applications being put on the street.
Okay.
All right. Delegate Lucas. Thank you very much.
I was going to give a less quality response than Alex.
Delegate Hornberger, do you still have a part two to your question?
No, I'm going to think on that and come back with some ideas.
All right, thank you. All right, any other questions as it relates to minority participation?
I do, Madam Chair.
Thank you, Delegate Barnes.
I was going to suggest that if George can give everyone a copy of the medical cannabis regulations, I think that would help them understand the direction that we intend to go as far as the regulations are concerned and the scoring mechanism as it relates to minority participation. Also, I want to circle back where we spoke briefly the other day on a provision that's in here on MBE sunset that I believe does not need to be in the bill. I believe it's on page 17, line 12. I think that MBE sunset does not need to be included.
Sir, would you repeat that?
I said there's a provision within the bill that I do not think that needs to be in there. It's an MBE sunset.
Yeah, I understand why you may have some hesitation regarding that termination provision. I would note that similar sunset provisions do exist for the other minority participation goal provisions in state law. There is periodic review of the state's disparity study, and to ensure that the disparity continues to exist and thus supports the minority participation goals and standards, and therefore assuming that the disparity is still found and the goals are determined necessary to address this disparity, then you would have future legislation to extend that date. But a periodic review is required.
Madam Chair, if I could, just a number of advocates have asked the speaker this question as well. So I just want to be sure that everyone is clear. This is actually what's legally required because the disparity study only has a finite amount of time that you can hold state law or licenses applicable under the disparity study. This language has to be included in the law. And I'm looking at Secretary Lewis nodding at me. And so Dahlia Barnes, as you know, we had to pass legislation, for instance, on the wind program to re-up the impact of the disparity study on that program. So this is something that's required constitutionally by both US and state law that has to be included in the bill.
All right, thank you.
All right, thank you very much for that comment, or for that information. Any other questions relative to minority participation? Okay, and to make sure that whether or not there currently are MBE goals for medical cannabis, we want to make sure if they exist or not. For reference. Okay. All right, the next topic will be certainly talk briefly about transfer of ownership. I'm not sure, George, if we completed that discussion, but are there any questions regarding transfer of ownership?
So one thing I would point to is that under section 9-1E03 of the bill, which is on page 11, under subsection A, the requirements under, in this instance, it would be 9-1A19 of the state government, of Title IX of the state government article, would apply to this subtitle. That section of code requires transfers of ownership in excess of 5%, I believe, to be approved by the State Lottery Commission. And so to agree that that is a matter of concern for the membership of this committee, I did want to flag that for you and ensure that you're aware. If you'd like that section of law incorporated more in its own stead here in this, as part of this legislation, then I can certainly draft an amendment to that effect.
Okay. I don't see any hands raised about that section. All right, the next category really centers around an amendment that was received a few days ago as it relates to prohibited wagers. Is there a question? Okay. George, would you go over that, please, for us? Prohibited wagers, persons prohibited from making or accepting wagers, and any other information you may have and questions of members. And I have a question following.
Okay.
That.
One moment, if you just give me a moment. So generally, prohibited wagers are going to be governed under section 9-1E, I believe it's 11, subsection A, generally speaking, of the bill. This begins on page 24, or sorry, 23, continuing on to 24. Those who are prohibited from wagering include those who are under the age of 21 years, who aren't physically present in the state, athletes, coaches, referees, directors, or employees of sports governing entities or their member teams, those individuals who have certain ownership percentages in the sports governing entity or the member teams, those who have access to certain information that is not available to the general public, those who hold positions of authority or influence that may influence the outcome or participation in a sporting event, That would once again include coaches, managers, trainers, those who are on a mandatory or voluntary exclusion list, certain operators, directors, officers, owners, or employees of the sports wagering licensees or online operators, or relatives of those individuals who are living in the same household, those who have, once again, access to non-public confidential information, or who are a category of individuals who are prohibited by the commission from wagering on a sporting event.
All right. Would you address amendment that was offered by Delegate Ebersol?
Yes, if you'll recall, a amendment was submitted by Delegate Ebersol that would extend this prohibition to instances where the sports wagering licensee is the owner of a professional sports team, or the professional sports team has a controlling interest in the sports wagering licensee, and where the wager is on either a sporting event or a portion of a sporting event in which the sports team is a competitor, or the performance statistics of an athlete of the sports team in a sporting event in which the team is a competitor.
All right, was that the only amendment in this category as relates to prohibited wagers?
Madam Chair?
I do not recall other specific amendments regarding these wagers. There are separate amendments that were requested that concern both problem gambling, as well as some protections or amendments that were offered by the NFL Players Association with respect to player safety, with respect to prohibited contacts with the players or referees or family members of those individuals, and regarding player personal data.
Okay, I have to be mindful of the hands. I'm sorry. Delegate Lukey, followed by Delegate Hornberger.
Thank you, Madam Chair. Just to your previous question, I also just forwarded to George an amendment that comes actually in an earlier section of the bill, but which is on a related topic. It would be in 9(1)(e)(04). So this is the section of the bill defining the role of the commission, and it would extend the requirement that the commission regulate the types of wagers on sporting events that can be accepted to also include a prohibition on wagering on injuries and penalties, and other forms that may be contrary to public opinion, which I think, similarly to some of the Players Association amendments, I think is intended to protect the health and integrity of players in the game.
Okay, thank you. Thank you for that. We'll get the amendment as well. Delegate Hornberger.
Thank you, Madam Chair. I had to pop up for a second. There's also a prohibition on gambling at any youth sports. Is that correct? That
is correct. They're not included as a sporting event under the definition of that term under 9(1)(e)(01). In addition, I also wanted to point out on page 25, subsection E, there is a procedure by which interested parties, which would include licensees, teams, leagues, associations, governing entities of those sports, or institutions of higher education, since collegiate sports are a permitted sporting event that you could bet on, where if the interested party believes that there's a type or form of wagering or category of individuals wagering on sporting events is contrary to public policy, unfair to consumers, or affects the integrity of a particular sport or the sports wagering industry, that those parties could submit a request to the commission to prohibit that type of or form of wagering, or prohibit a category of individuals from wagering on sporting events. And the committee would be authorized to grant that request.
Okay, and then just as a follow on, we have all these ideas right now, but this is a very evolving market on what can and cannot be bet on or what people are willing to bet on. Does the way that that's written preserve the ability for the commission to take action without legislature involvement if said, nefarious betting scheme does come up?
Yes, Delegate, that is correct. That the commission does have fairly broad regulatory authority under the bill as constructed and would be able to act accordingly.
Great, thank you.
Well, thank you. I believe that if there are no other types of waiver player protection matters, I don't see any hands here. I want to thank everyone for coming on for part 2. We're going to continue. This will be a very long day. We will reconvene at 6:30 tonight for 2 hours, if necessary, to go over key other issues and aspects of House Bill 940. So for this juncture, I will say thank you very much, and we look forward to seeing you later this evening.